up and running, are we?
Training on a couple of occasions. So
Okay. Okay.
staff,
Okay. Answer. Okay. Cool. I'll keep it running. Are you going to be able to edit once we
Lights on it. Turns on.
Okay. Okay, cool. So the live stream is currently on and will be on through the duration of the hearing. So you need to bear in mind it needs to be conversations with applicants related to the case.
Thank you. The link is still going through to 74.
We're sorting that out.
All right.
Cool. Hello? Yeah, I can't go through that.
That's okay.
I'll do the same sort of I'll place you on
Just at the accessory on the way here. Morning, Ian. Morning.
So we've got the live stream already working.
Oh, excellent. I know there were a few issues.
But just send us the link.
Excellent. All right. Fantastic. Cheers. Bye. Should now be where YouTube.
Well, that's good. I'm sure we've got a very big audience somewhere.
Yes, absolutely.
They knew you were coming, you see, so they would have said. And Robin, I know, is very keen on the Twitter sphere, aren't you, Robin? So you will have broadcast it high and far, I'm sure.
In my life. Have you seen one that's broadcast?
If you're looking for it, the best thing to do is to close it and restart it again.
Well, only indirectly in the sense I did a hearing with the judge and it was all remotely done, so I suppose then I saw a bit of it, but
The actual screen itself, I think, just shows the bench, it doesn't show the advocate.
oh, doesn't it?
No, I think it's taken from that.
Oh, right, okay.
And it's just the bench. You might be able to get the advocate's wig.
Yeah, I've seen a bit on the
But that's if it's
Supreme
remote.
Court.
If it's in person, I think it does pick up.
Really?
I think you may not be a bit. Is it too far
There are
out?
cameras here, remember? There are cameras here.
Yeah, I think. Yeah.
And that one has. That one's been. Oh. Wow.
I don't know.
On the one I did, I said,
Good,
everybody
we finally
turn
got
off
sorted yesterday.
their pictures,
Yeah.
except the advocates, because I wanted to see what the advocates look like.
Who is that, Tim?
Well, I wanted to see expressions
Make
of
sure that your good side is shown.
anxiety or otherwise. I wanted to be able to gauge that. It's good up there, it says session live.
Let's quickly check as well that everyone's got their mobile switched off, that need to have them switched off, please.
Yeah, I just saw him there. Disappeared.
You can, but I'll stay here just to
Have
make
you
sure.
been okay?
Yeah.
Are you here pretty much all the time, or just when you're just sitting?
No,
or-
that's really good.
At the moment.
your message second. You got a metal bit,
Let's try again.
Yeah.
I never know.
There's a metal bit of it.
No, it's
Yeah.
not good looking.
No, it's not, is it?
It's not good looking
It's
anyway.
like Tonto on the bench, isn't it? All you need is a hat, a Stetson with it, and somebody thinks you're being held up at the OK Quran.
I I don't know if we actually need to seat them because last week you can seat them.
Yeah.
Yeah, I'll see what they want to do.
Yeah. Well, when we were in CACD doing vacation duty, I just said to them, this is quite cramped on the bench, this is quite spacious in comparison.
Yeah.
I said, in line with social distancing, is it okay if you seat yourselves? I'll just knock the door, usher and say, all rise, and you take your seat. And he went, yeah, that's fine. So,
I'll see when they
Yeah.
what he wants to do.
Everyone's wearing masks.
Yes. Well, last week I didn't, and I felt like the odd one out. Everyone else was wearing them.
Apparently, I think judges in this
Just
just when they come in and they're going
Just
to take
make
it.
them
Yeah.
And there was an email that said,
That's a good example.
the other side of the homes.
we were sitting there last week, so that's why we sort of just followed exactly what he was doing.
Well, it wouldn't be possible.
See if
Actually, we can't sit.
When did he?
We can't sit.
Yeah, see, last week again, even with the I couldn't seat them, they just sat themselves. So I'll see what they want to do. But if that's fine with them, that's fine with us and you, I'm sure.
I doubt I did that. I probably just spoke on the phone. 23rd. Fair. 5th or thereabouts. That's when the acknowledgement is supposed to be.
Definitely.
Who, Trevor? Oh,
I think you might even be watching today.
oh, right. Hello, Trevor.
Yeah.
Yeah. Dear old Trevor.
The judges are here.
Yes.
Is everyone ready?
Thank you.
Good.
Yeah.
My number? 4864. Yeah.
All right.
Appealing the matter of Easter and Mid-Suffolk District Council and another.
May it please the court, I appear on behalf of Debenham Antiques Ltd. My learned friend Miss Hutton appears on behalf of Mrs. Easter, who is my client's neighbour, and Mr. Green appears on behalf of the local council, the planning authority, the decision maker. My lords, may I proceed to take everything as read, that is to say 3 skeleton arguments. There are 2 bundles, the first of which runs to 168 pages, and to indicate with the court's leave that I propose to be brief. And I would ask the court, if I may, to start at paragraph 11, page 28, the judge's reasons for the which is under appeal, pursuant to the permission given by Lord Justice Lewison. And paragraph 11 is the heart of this matter, and in my respectful submission, every single sentence within that paragraph is wrong. Notice, please, that it begins by saying after the 5th of February, the interested party should pay the claimant's costs. After the 5th of February means that, contrary to what Miss Hutton was saying, the interested party is having to pay the costs in front of Mr. Justice Holgate for the permission hearing. And then it goes on to say, that sentence, that the interested party interested person took the burden of defending the claim by applying to file an acknowledgement of service out of time with summary grounds. This asserts a particular burden is taken, but is contrary both to the facts and to the rules. As far as the latter is concerned...
Can I just stop you for a moment? When you
of course.
It's correct to say that you applied to file acknowledgement of service out of time together with summary grounds. That's correct?
That's absolutely correct. And the reason for that, I'll show your lordship in a moment, because unless one has done that, one is not able to be heard at the permission stage. The court is able to say, go away, and I've had that happen to me.
So
before.
is the phrase that you're drawing our attention to, the phrase it plainly took on the burden of defending the claim? Is that what you're complaining about?
Absolutely, absolutely, because we took on no such burden at all. Incidentally, of course, there was at that stage no claim to be defended because Mr. Howell, on a previous occasion, that is to say the 23rd of January, had refused permission for the matter to proceed. But if you go in the bundle of authorities where has been set out the entirety of Rule 54, which governs judicial review, you will see behind flag 8 at 54.8, which begins at the bottom of page 6/13, any person served with the claim form who wishes to take part in the judicial review must file an acknowledgement of service in the relevant practice form. An acknowledgement of service over the page must be filed not more than 21 days after of the claim form. And then if you look down at 54.9, you will see that where a person has failed to file an acknowledgement of service, he, A, may not take part in a hearing to decide whether permission should be given. The purpose of filing an acknowledgement of service is to enable one to appear at the permission hearing, which, as seems to be the case, all agree had in any event to take place.
No, I don't think that's agreed at all.
Well,
What's agreed is that there had to be an application to renew. It's not agreed that there had to be an oral hearing.
Well, that's asserted by reference to CPR 40, which doesn't actually cover the point. And CPR 54 provides that the only route to enable permission to be given is that of a hearing.
I don't think that's true at all, Mr. Straker. In my experience, sitting as a High Court judge, it was not unusual for the parties to agree that things could be resolved by a consent order. That would obviate the need for an oral hearing.
Well, my lord, there are stages which have to be considered. The first stage is what CPR 54 actually provides for, that if you are refused permission, you cannot appeal, but you may renew it at a hearing. Yes. At a hearing.
No, you may renew it.
Yes, you may renew it, and you may come to be granted it at a hearing.
But if the parties were at that point to agree that, in fact, there was no need for there to be a contested hearing, and they were prepared to sign a consent order, then of course that wouldn't be something the court simply rubber stamps. But in practice, that often does obviate the need for a hearing.
Well, my lord, I confess that I haven't come across that particular matter. It may be that I'm too contentious in regards to these matters, but I've not come across that particular matter. I can readily understand a circumstance whereby when a hearing has been arranged, and this hearing was in front of Mr. Justice Holgate, was arranged prior, in fact, to the acknowledgement of service being filed. And I can show your lordship the correspondence.
Do we get any help out of 54.18, which is on page 11 of 13? Saying that the court may decide the claim for judicial review without a hearing where all the parties agree.
We get no particular help out of that. I say that because that refers to the judicial review being decided without a hearing, which is in fact what happened here in front of Mr. David Elvin. But it doesn't refer to the question of permission to seek judicial review.
Why should there be a difference?
Oh, because there is an undoubted difference on the rules, because you have the circumstance whereby 54.12 provides for a permission decision without a hearing, and then provides at 54.12.3, middle of page 9/13, that subject to paragraph 7, which is not applicable here, the claimant may not appeal, but may request the decision to be reconsidered at a hearing. And so you have, and you very distinctly have, in the process of judicial review leading up to that potential for judicial review to be decided without a hearing, 54.18, a kind of two-step, the first step of which is the lodging of the claim by the potential claimant, the second of which is the permission hearing, and after that you have the judicial review, which may be decided without a hearing.
So is it your submission, Mr. Straker, that although the substantive claim for judicial review can be resolved without a hearing where all the parties agree, a renewed application for permission cannot be.
Well, the only route to it is provided in CPR 5412, which is reconsideration at a hearing. And there is very good reason for that, my Lord, in my respectful submission, especially in this field of activity, where you have a circumstance whereby Mr. Howell refuses permission, saying it's unarguable. The council had indicated a willingness to consent in respect of an aspect of planning control, which is of both public interest and of value to someone else, in circumstances where if a council wishes to get rid of a planning permission, as it might often do, it may regret having granted a planning permission, it can only do so by a process of revocation under the Town and Country Planning Act 1990, which carries with it a requirement to pay compensation. And so you do not want to have a circumstance where you provide a situation which is, if I can put it this way crudely, without seeking to put it in legally sophisticated terms, too easy to provide for a local planning authority regretting what it did 6 months ago or something of the sort, to say we will now consent to judicial review and let's proceed in a way which we just sign on the dotted line. There doesn't have to be a hearing, and there we are. Now, my Lord, there may very well be hearings in which one party has written in to the court and said, I'm sorry, I'm not going to attend, but I wish to draw to the court's attention the fact that there is an error that here has been made, and therefore you should grant permission. And the court, no doubt, would take that into account in deciding whether to grant permission, and there will be a short 1 minute hearing, effectively. But that there has to be a hearing, because there is no other way under the rules of securing the grant of a permission. No other way. Now, you could stretch, it may be supposed, the definition of a hearing to include the judge sitting in his own room, just as Mr. Howell had sat in his own room and determined there should now be no permission, but the rules aren't actually structured like that. They provide for a hearing. Now, the acknowledgement of service was done with that in mind, and it was on the 5th of February 19, short while before the hearing in front of Mr. Justice Holgate on the 27th, and as I indicated to my Lord Justice Singh, the hearing date had, prior to the acknowledgement of service, been signified as being that which actually came, I think, to occur. If you look at pages 86 and 87 of the bundle, in fact, I think it was a little later than the date here given, but on page 86, you'll see in the later of the two emails, the JR renewal hearing has been set for, that's the 1st of February, before Debenham Antiques had done anything by way of acknowledgement of service. Prior to that, 30th of January, going over the page, hearing date has been set for 21 of February. So it was known that there was going to be a hearing date and when it was going to take prior to the acknowledgement of service by Debenham Antiques. The next here is that there was, if permission came to be given, a circumstance whereby the interested party could then decide if he wished to contest the claim. So if you go back to the bundle of authorities, flag 8, at 9:13, the response, which begins at the bottom of the page, response 5414. This is after a hearing has determined that permission should be given. Top of page 10 of 13. A defendant and any other person served with the claim form who wishes to contest it, the claim or support it on additional grounds must file and serve detailed grounds for contesting and any written evidence within 35 days. And 35 days is not a happenstance that that period of time was chosen, because you've had 21 days in order to put in your acknowledgement of service, and then you get 35 days making 56, which reflects what is under the rules of the Supreme Court. When one had ex parte applications, you then had 56 days to decide what you were going to do. So it's not a happenstance, and it's not a happenstance either, in my respectful submission, that the language there used is who wishes to contest the claim.
So why are you showing us this rule? Because in fact, as I understand it, on the facts of the present case, you did not file detailed grounds for contesting.
Absolutely right, my lord. We, on the 8th of April, through Sharp-Fritchard, 8th of April, signified we're not taking part in this. We're not going to do this. We don't contest this claim. And subsequent to the 8th of April, as your lordship will have undoubtedly seen, there was correspondence between the claimant, Mrs. Easter, and the local planning authority as to which of the grounds they were going to concede upon. There was correspondence and discussion about that, in which we played no part. So after the hearing in front of Mr. Justice Holgate, all that Sharp-Pritchard did effectively was to write a letter on the 8th of April saying we're not playing in this game.
I understand that. I was just curious, why is this rule that you've just shown us relevant to the present?
Oh, it's relevant to the present point because, my lord, when one looks at what the judge says in paragraph 11, you took the burden of defending. Absolutely no, we did not take the burden of defending. We took the step necessary in order to be able to appear at the hearing when it was going to be decided whether or not there ought to be a claim. And thereafter, we said we're not playing in this particular game. We never took on the burden of defending the claim. You don't take on the burden of defending the claim by applying to file an acknowledgement of service. The express purpose of the acknowledgement of service is, as was recognised and is set out in the rules, the purpose of being able to appear in front of Mr. Justice Holgate.
And why did you want to appear in front of Mr. Justice Holgate?
Well, the reason to appear in front of Mr. Justice Holgate is, A, partly to see what is actually going to happen, and B, to be, if possible, of any assistance to the judge in the hope, from the point of view of the client, that the judge would say Mr. Howell actually was correct. That is the rationale for appearing, but you can't take, in my respectful submission, a further step from that in saying, well, you have thereby taken on the burden of defending this whole claim, which is a claim not against me, against the local planning authority, not in respect of any decision I've taken, but in respect of a decision taken by the local planning authority, in which there's a public interest, in which they continued up until the end, May or thereabouts, to negotiate with the claimant as to the grounds upon which they should concede.
So you wanted to appear in order to seek to uphold the refusal of the application for permission?
Yes.
So you were a protagonist at that hearing? I
think that must be, in my respectful submission, a way in which it can properly be put, but it's, in my respectful submission, slightly more than merely a protagonist, because if, as in fact came to be the case, the judge signified an approach rather different from that taken by Mr. Howell. It was of some value to my client, to Debenham Antiques Ltd, to be present so as to see the way the wind is blowing. But it doesn't follow from being present to see which way the wind is blowing that one is taking on the burden of the sales preventing that wind going in any particular direction.
Am I right in understanding you'd served a skeleton argument in advance of that?
No. No.
Who had? Because Mr. Justice Holgate refers to the skeletons that he's
Well,
read.
Miss Hutton certainly had, but I hadn't. We'd done a acknowledgement of service with some grounds which set out and said Mr. Howell knows all about it and his decision is correct. It said rather more than that and didn't say it in quite those terms, my lord, but that's the gist. So I readily accept from my Lord Justice Moylan, that one can describe me there as being a protagonist, but I do add to that, it's more than merely a protagonist as to why one should want to go along to this sort of circumstance. Now, my lord, if one goes back to paragraph 11...
Can I just ask you, in the supplementary bundle, at page 197, behind tab 2, do you have page 197?
Yes, my lord.
You're quoted in the transcript at the beginning of that page against letter A. And in line 2, you're recorded as saying, as I put it in the skeleton argument. Is that wrong?
Page 197, my lord.
Yes, tab 2, supplementary.
Oh, well, in that case, what I must have been doing, I don't recollect that there was a skeleton argument by me. I must have been referring to the grounds.
I see.
So that's likely to have been a mistake by me,
Yes, I see.
as to what was being said, because, as your lordship will readily appreciate, the distinction between the two as written is perhaps a fine distinction. My lord, then, if one looks back at paragraph 11, page 28 of the bundle, second sentence says, whilst it's fair to acknowledge the amendments to the grounds following the oral hearing, the fundamental grounds survived, the amendment didn't amount to a wholesale replacement of the grounds. Now, this, of course, assumes that there were still extant grounds, whereas Mr. Howell had indicated the claim was unarguable. Second, if you look at volume 2 of page 211, which is part of the transcript that my Lord Justice Singh was just, part of the amended statement of facts and grounds.
Sorry, what page?
211, my Lord, volume 2.
Thank you very much.
If you look 211, the application is brought on the following grounds. They're all crossed through, and then ground 1 originally unlawfully failed to take into account the use of the extension, and then ground 1, the council's treatment of the use of the development was unlawful. It failed to consider whether there was any lawful use at the site. And this reflects a different approach to the case, because what Mr. Justice Holgate had pointed out was, you've got to think about, and I'm putting this in general terms, you've got to think about what happens if the present use is not deployed. Can you go back to something? Because previously it had been a petrol station. And that was the aspect which founded some discussion in front of Mr. Justice Holgate, but produced, and one can test this by looking on to page 220, a very different set of challenges which were then put. Ground 1 at 220, and one just needs to flick over the pages to see that everything is underlined. And if you look at page 106, this takes the matter beyond the date of the hearing of Mr. Justice Holgate, but the last complete paragraph, if the council is not willing to concede on all 4 grounds, and these are now the 4 new grounds, and cover our client's cost to date, then our client will be strongly advised to pursue the judicial review to a full substantive hearing. Sharp Pritchard have said we're playing no part in this particular game, following on from what Mr. Justice Holgate had said and dealing with the claim as now pleaded. Now, the next sentence in paragraph 11 says, at the interested party's position, an oral hearing and the preparation for it are unlikely to have been necessary, and the subsequent costs would have been very significantly reduced. Now, first of all, if we look at page 130 in the first volume, you will see what has been expressed in a decision by Mrs. Justice Andrews, which was put before the court in this case, and refers to the starting point for consideration, paragraph 18 at the top of 130, statutory reviews under 288 have a public law element. Section 288, as your lordships may know, is the route by which you challenge the Secretary of State when he has given planning permission, so it's exactly the same as the circumstance with which we're here concerned with. And this means that even if the claimant and Secretary of State both concur that the decision should be quashed and also agree as to the basis, the court must be satisfied. Therefore, even if the parties have signed a consent order, the court would have a final say, and so forth. And then a further aspect of this matter relates to the requirement whenever a planning decision is quashed by consent to define transparently and with proper particularity the ambit, and that's been underlined by Mr. Justice Holgate. And he went on to observe, paragraph 20, an unexplained concession is just as unacceptable as a draft consent order. Those comments were fully endorsed. And then we've seen, secondly on this point, CPR, and we've seen how there is in fact under 54 no other route to get a permission without a hearing. Now, I readily accept there's been a debate between me and Lord Justice Singh as far as that is concerned, but on the terms of the rules, CPR 54, there is no other route bar that of a hearing, and the hearing was made and sought prior to any involvement here of the interested party. And indeed, if you look on in the volume 1, you will see that at page 145, one is within the submissions on costs of the claimant paragraph 7, the defendant, that's not me, that's the local planning authority, never signed a consent order. It did not inform the court that it was proposing to consent to judgments, and events were subsequently overtaken by a refusal by Mr. John Howe, Queen's Counsel, sitting as a Deputy High Court judge. This is an ordinary part of litigation which flowed from the defendant's unlawful decision. The claimant had to then renew its application and ultimately succeeded before Mr. Justice Holgate, with that judge suggesting additional grounds. The clear judicial direction at the permission hearing led to the council, the local planning authority, conceding on all grounds. And then if we look over the page, paragraph 15, bottom of the page, the primary submission of Ms. Hutton had been that the defendant counsel should pay. Paragraph 15, if the court accepts the defendant's submission that it ought not to pay the costs relating to dealings with interested party, then clearly a proportion of costs should be paid by the interested party. Then notice these words, please. Although this would not include the cost of the permission hearing, as clearly that was not the result of the interested party's actions, but was the consequence of a refusal of permission on the papers by Mr. Howell, an ordinary incident of litigation flowing from the defendant's unlawful decision. My lords, I can, so to speak, interpolate at this stage that my learned friend Miss Hutton now appears to say that CPR 40 at flag 7, Bundle of Authorities, enables matters to have proceeded differently. And this deals with consent judgments. It's flag 7, CPR 40.6. And it refers to particular types of judgments and orders, C46.3. It enables, when the parties have agreed with the court officer to enter and seal 1 and 2 in certain circumstances, but the judgments referred to in paragraph 2 are, and then they're listed, and they don't include that with which we're concerned with. So, in my respect, we've got, as might be expected, in CPR 54, the descriptive way in which one secures permission, and to a considerable extent, and there are obviously some other parts of the CPR are applicable, but we've got to a considerable extent its own bespoke procedure.
Suppose, Mr. Straker, before an oral hearing takes place, the defendant authority wishes to concede the substantive claim for judicial review. Can they do that without a hearing?
They wish to concede before permission has been granted.
Yes.
They wish to concede. They can't do that without either permission having been granted on the papers, that is to say, stage 1, so to speak. If permission has been refused on the papers, there has to be a hearing, notwithstanding the willingness of the local planning authority. It may be that that hearing comes to be abbreviated because the judge hearing it has before him the claimant, and the claimant points out, you haven't got the local planning authority here, but they have written in to say, agree with our analysis of, and that therefore this is appropriate for permission to be given, and in due course for judicial review to be given. Be how that would work.
They can't just file a consent order saying the following steps are ordered by agreement. 1, permission granted. 2, substantive claim for judicial review allowed. 3, decision quashed.
No, No, absolutely not. And it would be, and in the circumstances that confront the court, it might be thought that we're here dealing with problems between two neighbours, and it's not the matter of the greatest moment. But there would be circumstances, my lord, where the approach, if one could do that, would be extremely hazardous as far as the public interest is concerned. One doesn't want to sound pompous about it, but a planning permission, when granted, is said by the Act to inure for the benefit of the land. That's section 75 of the Town and Country Planning Act. So you've got something which is there, tangible, inuring always for the benefit of the land. And to have that swept aside with a consent order being filed of the kind that my lord has just been mentioning carries the grave risk that you'd get planning permissions overturned which ought not to be overturned in circumstances where, if they were properly going to be set aside, it should be by way of revocation, which would carry compensation.
Forgive me, can we just break this down, please, into different kinds of cases? First of all, the planning permission scenario which you give. The sort of consent order that I'm referring to could only be made if not only the defendant public authority, but also the interested party, the beneficiary of the planning permission, also consented.
Well, my lord, the position as far as the consent order is concerned, it doesn't technically require the signature of the interested party or the potentially interested party. And the difficulty in that scenario of identifying who may be all the potentially interested persons, because it may be for a large development and one's concerned with a considerable number of persons who are potentially interested in the prospective development of a site.
Now, what I mean is, I don't want to be unduly technical about this, but an interested party has a particular meaning in the rules. It's the person who has been served with, because no doubt they are directly affected by the claim for judicial review. And typically, as in this case, that will be the beneficiary of some license or permission which is being granted by a public authority.
Yes.
So here, there can be no doubt about who the interested parties are. Your client was an interested party. It does seem to me, speaking for myself at this stage, that there's no realistic way in which a court would agree to any kind of consent order quashing the grant of planning permission unless the interested party also consented.
Well, my lord, your lordship may well be right, but if one's concerned with the base question with which this judge dealing with the costs dealt with it, did there have to be a hearing in front of Mr. Justice Holgate? What the exchange between us has answered is not that particular question, did there have to be such a hearing, to which I say the answer is undoubtedly yes. And you can test that, if you like, by looking onwards as to what may happen after the grant of permission. We're simply discussing a mechanical exercise in which it would be expected that someone in the position of Debenham Antiques Ltd would sign on a dotted line. And I don't dissent from the proposition that that would ordinarily be expected, not necessarily required, but ordinarily expected. And one shouldn't personalise these matters, but if one was doing it oneself, one would say, yes, I want that, please. But if one reflects further to deal with your lordship's point and a point about what about the hearing of February in front of Mr. Justice Holgate, was that necessary? Think on a bit as to what the rules provide for the judicial review hearing. At the judicial review hearing, those who have been served, such as interested parties, can say, no, we're not going to be bothered anymore, we're not going to do detailed grounds. But other people at the hearing can come along and put their hands up and say at the judicial review hearing, I would like to be heard about this particular matter. And so it's rather strange to say that one can just, so to speak, hold in the grip of one's hand the entirety of the disposal of the case as between a very limited number of persons without going through what is actually required under the legislation.
Right, well, I thank you for your answer. In relation to that scenario, can we take the more simple scenario? Because as it happens here, we're dealing with a case where there was an interested party. But often in public decision making, there is no other party. There are simply the two parties. Let's say it's a housing case or a children case, whatever it may be. It's just a local authority and a member of the public who's the subject of that decision. Now, suppose the scenario arises where permission has been refused on the papers, but there's a renewed application for permission, and before an oral hearing takes place, the local authority, perhaps because they take council's advice or for whatever reason, on reflection, they decide that they do not wish to contest the substantive claim for judicial review. Is it your submission that before the oral permission hearing, they cannot simply agree to an order of the terms that I suggested earlier? 1, permission granted; 2, substantive claim for judicial review allowed; 3, decision quashed.
No, because there is no extant claim for judicial review.
Yes.
There still has to be granted permission for that claim. Under the rules, there still has to be a hearing, which of course could take the form, my lord, to go to your lordship's point of a local authority puts its hands up and says, we realise we've done something wrong here, could take the form of letters to the court, both by the claimant and by the local planning authority or the local education authority, whatever it may be, saying there has been this mistake here, there has to be a hearing in order to get permission for judicial review. With the court's leave, no one is going to turn up, but please could the court, as it frequently does, in the absence of the parties, make the necessary enable this judicial review to occur. And then you have met the terms of the rules. You have also provided for the circumstance of the situation where if there's some unforeseen person who wishes to take a view in connection with this matter and wishes to say something, to come along actually to court and to say something about it. And you have done it all in the most open and transparent way, concerned as you are with matters of public interest. Because even in my Lord Justice illustrations of saying there's nobody else involved, generally speaking, there will, even if they're not readily identifiable, be other people involved, because ordinarily decisions will be about and touching upon the allocation of resources in which you do have widespread interest from others. Allocation of housing under homelessness provisions is the denial of housing to another.
So do I understand you to be saying that you can fulfil 54.12.3, the requirement to have a renewal hearing, by a hearing which takes the form of nobody turning up because and the judge simply being in open court and approving the consent?
Yes.
And in that case, none of the costs would be incurred, which were incurred in the hearing before Mr. Justice Holgate in this case. So how does that help you?
Well, it helps me substantially in the sense of I've provided an answer to my Lord Justice Singh and to the court, I trust, but also I've dealt with the matter from the point of view of practicality. Here, the position was one where there was always going to have to be a hearing, as is acknowledged in the correspondence between the council and the claimant, Mrs. Easter, as we've seen, and is said elsewhere as well. There always was going to have to be a hearing, partly because the circumstance was one whereby...
I'm sorry to interrupt you. It could have been a no-cost hearing of the type I've just described. To say that there was always going to have to be a hearing, it could have been a no-cost hearing, but it wasn't because of the stance that you had taken filing
no,
grounds for resistance.
With the greatest respect, no, because the hearing had already been determined upon prior to any indication of acknowledgement of service. We've seen that in the correspondence, that is so. And we've seen that 31st of January, 1st of February, there will be this hearing, and we've seen what the claimant has said about it. To attach to the illustration which I gave, where you could have, in what I will categorise as a simple case, the circumstance of no hearing, no effective hearing. I mean just a hearing when the judge comes into court to say, I've read the papers and this is what's going to happen. You can't read that across to this circumstance for a number of reasons, including the fact that there had been an authoritative and clearly, carefully thought through set of reasons whereby the claim as pleaded had been refused by Mr. Howell, who plainly has a huge amount of experience in these areas. And so it had been refused by him. And so consequently, it was never going to be a sort of circumstance in which there was going to be an exercise whereby it's going to be a simple exchange of correspondence, because as in fact happened, it needed the input of Mr. Justice Holgate to send the case on a somewhat different trajectory from it had previously been upon, which required to be responded to and then pleaded to by my learned friend Miss Hutton. So what one can't do, my lord, is to draw from the circumstance where I'm being pressed with the situation, well, aren't you, Mr. Straker, making it very difficult when there's an obvious case and we've got to go through some judicial labour and turn people up to court? Aren't you making all that difficult? No, I say, in the very simple circumstance you can deal with it in the sort of way I described. But that doesn't mean that for this situation, the situation is as one whereby the responsibility for the hearing can be placed upon the interested party. And the next sentence in the paragraph 11 says that we didn't formally abandon resistance until the 18th of the April 2019. But first there was no resistance formally or otherwise to abandon. After permission, it had 35 days to decide whether to contest the claim, 44.14.1. And page 104 of the bundle shows what in fact took place. Flag, page 104, flag 7 of the bundle. '8th of April 2019, not the 18th. Interested party has decided not to submit detailed grounds of resistance in this claim. Sent by Sharp Pritchard, referable clearly to the CPR, so everybody would know they are not electing to defend. And then if one looks on at page 103, before the letter of the 8th of April, we have from the council, from Ian Dupre in the middle between the two hole punches, with regard to the judicial review, and the reference number is given, we have noted the revised grounds. Our position remains that we're willing to consent to judgment on the reasons ground number 4, And then subsequent to that, there was correspondence, some of which I've shown the court already, page 107. If you're not willing to concede, we're going to pursue it. And then page 109 from the Council, 10th of May 2019. We shouldn't consent to judgment on terms that properly prevent us exercising our development control functions. And then there's discussion about these matters. I don't need to read it out, but there was debate about the way in which this should be dealt with. And so we have a circumstance, in my respectful submission, where it's abundantly clear that the hearing in February in front of Mr. Justice Holgate was going to happen anyway, where after the hearing in front of Mr. Justice Holgate, the interested party effectively did nothing beyond say we're not going to participate in this matter, we're not going to contest it. While subsequent to that, there was debate about the terms of the order, but we, Debenham Antiques, have been landed with the costs of everything post the 5th of February, in circumstances where we have never been the defendant, we've never formally been actually a party, and we've never caused any expense to be incurred. And if one looks back at the paragraph, the judge continued by saying that Debenham Antiques, middle of the paragraph, had contributed to the delay and cost in providing a consent order prior to the 23rd of January 2019. But no one suggests that we did anything prior to the 23rd of January 2019. And the Debenham Antiques weren't represented at that stage. The position was one whereby, if you look at the situation in the witness statement in support of costs recovery, page 37, behind flag 7 in the bundle. Let's look at the listed items at paragraph 3. There's one reference to the IP, but that was about contact with, nothing to do with us having delayed anything of any sort. And all that appears to have gone on is page 48 and 49, the interested party not being represented at that stage. Wasn't quite sure what he was going to do. But certainly not taking any steps to delay anything of any description whatsoever. And we've seen in the way in which this happened, that Mr. Howell, acting no doubt, having been given the papers to do, did it perhaps earlier than some might have done, or did it quickly, but came back and had said this claim was unarguable. My lords, there are other points. I'm conscious of the time, my lord, in connection with this. The relevance of the other case referred to in paragraph 11 is that it shows the usual practice, which of course is that conscripts, i.e. defendants, are liable, not volunteers, interested parties. The material post Mr. Justice Holgate had nothing to do with us, and if one goes back to that paragraph 11, where I say every sentence is in fact wrong, she refers to the order made by Mr. Elvin and can't see how any part of that gives any indication. Well, if one looks at that, there's a big schedule dealing with the way in which the grounds as they emerged post Mr. Justice Holgate were dealt with, nothing to do with us. Not fair to suggest the defendant agreed to sign a consent order after the IP, as the defendant was willing to sign the consent order agreed between it and the claimant for some time. It was not until, well, that's not just not borne out by the correspondence, and it was nothing to do with us anyway. And then she says, you should pay the claimant's costs incurred after the 5th of February 2019. And so we have been landed with this bill which embraces the hearing in front of Mr. Justice Holgate, which had to happen and which had been forecast before and which has been stated as having had to happen. We've been landed with the costs of all the negotiations, presumably between the council and the claimant, post Mr. Justice Holgate, on the grounds upon which they were going to concede. Absolutely nothing to do with us. All in circumstances in which we had said, at more or less the earliest possible stage, under the rules, we are not going to participate in this particular exercise. And in my respectful submission, it just means that the situation is one whereby the whole basis upon which this judge proceeded was wrong, I'm afraid to say. And the primary submission of the claimant, Mrs. Easter, was that the defendant, who had made the decision in the first place, who had then had to concede to the decision after we had withdrawn from the proceedings, but following the discussion about the grounds as given by Mr. Justice Holgate, then led to that happening. But we've been landed with that particular bill, and I say that is frankly monstrous. And I also say that legally it is entirely indefensible when one goes through that paragraph 11, or in fact any other part of the reasoning. But that is the one which simply leaps out as not being something which is sustainable. My Lords, as I say, I was conscious of the time, and I'm proposing to leave matters there unless you would wish me to develop matters further.
Well, we've asked you a lot of questions, Mr. Straker, so if there's anything else you would feel you should draw to our attention, I would invite you to do so.
My Lord, I don't think there is immediately. The one is one of fundamental, if I may say so, importance in recognising that we were not responsible for that hearing of the 23rd, and I've shown your Lordship the correspondence by which it had been determined beforehand. And no one has said that it could have been dealt with without that hearing in front of Mr. Justice Holgate. There are, if I may put it this way, without in any way being disrespectful, theoretical circumstances where that kind of hearing could have been abbreviated in the sort of way that I discussed with my Lord Justice Singh, but this was not one such case. This was always, if one wants to view it in old-fashioned terms, an old-fashioned situation where one had to go to court in order to get the permission to have the dialogue to see how is the case going hereafter actually to function. And that is what happened, witness the large-scale amendments which took place and prompted by Mr. Justice Holgate.
Any other questions? No. Anything else? No. Thank you very much. Yes.
My Lords, thank you. If I could first deal with a few of the legal principles, and then I will turn to each of my learned friends' grounds. But my headline point is this, that this was all a matter for the judgment of the court below. And as at the 5th of February, when the interested party filed its acknowledgement of service out of time, it became the only active defendant to the proceedings. And my Lords, in those circumstances, it was quite within the proper bounds of the judge below's judgment to reach the view that the interested party should pay costs from that date. And my Lord, just while I'm on this point, if I could just deal briefly with an exchange which was had by your lordships and my learned friend as to the significance of the acknowledgement of service. The acknowledgement of service on page 75 of the bundle, and this was the document filed on the 5th of February, and I think it was said by my learned friend that it was so that the interested party could see which way the wind was blowing. But of course, if one looks at page 75 and section A of that document ticked clearly there, I intend to contest all of the claim. There was also on page 77 a denial that the claim was an Aarhus Convention claim. Now, of course, that's only relevant in relation to costs and the cost cap. And then it was accompanied by grounds from my learned friend on pages 79 to 81. So the court can be in no doubt that the claim was very much being contested by the interested party. It wasn't simply a question of wanting to turn up and see what happened. It's also clear, my lords, from the transcript of the hearing, and my lords, I don't propose to take your lordships through it, to note that in that the detail of my learned friend's submissions starts at page 196.
I'm so sorry to interrupt you. Can I just take you back, please, to the
Yes.
acknowledgement of service and
Yes.
summary grounds?
Yes.
And just so I can you remind me of the date of this? It's headed at page 8, sorry, signed by Mr. Straker at page 81, but the precise date is not given. It simply says February 2019.
Yes, my lord. So the date on the acknowledgement of service
Page
is
78.
page 78, which
Yes.
is the 5th of February.
Yes.
And the grounds were appended, and one can see that from page 76.
So we can
See
take that to
attached.
be the 5th of February,
We can take that to the 5th of February.
which presumably is why the judge took that date as the cut-off point.
Exactly. And my lord, from page 196,
Sorry, so page 76 identifies that those are
Yes,
the summary of the grounds for contesting the claim,
exactly,
which are referred to in the acknowledgement of service.
yes.
now, my lords, from 196 onwards is an exchange between my learned friend and Mr. Justice Holgate. And, my lords, I don't propose to suggest that the court reads it in detail, or indeed I read it. But essentially, from that moment on is the exchange whereby my learned friend was clearly contesting the grounds for the claim. And then later on, and I'll come to it later, also contested the cost cap, which the claimant was asking for. My lords, I should just say that my learned friend did put a skeleton in to the renewal hearing. I've got it now. It's just been forwarded to me by my instructing solicitor. It was 4 pages long and is dated the 21st of February. My lords, given the skeleton follows the grounds, summary grounds that were put in, and it follows the exchange which my learned friend had with Mr. Justice Holgate, I'm not sure that the court needs to see it, but I can provide copies if necessary. So it's a rather long introduction, my lords, but really the headline point is this, that from that date, given the council had confirmed back in November the year before that they weren't contesting the claim, given there was only one defendant from the 5th of February, it's entirely unsurprising that Her Honour Judge Evans-Gordon, as a matter of her judgment, took the view that the interested party should pay costs from that day. But with that in mind, my lord, if I just turn briefly to some legal principles and then to each of the grounds. My lord, this court has dealt with the issue of awards of costs on a summary assessment a couple of times this year, but perhaps the most helpful authority is the authority of Tarveen and Redbridge, London Borough Council, at tab 4 of the authorities bundle, where Lord Justice Males gave a useful summary of the principles, and I hope that I can run through these fairly swiftly. Paragraph 23 of Lord Justice Mill's judgment, there is cited a passage from Burgess and Leonvarn, which essentially is the principle that the court can only intervene in a cost award from a court below where there is an error of law or the discretion of the trial judge was exercised in a manner which led to an unjust or perverse result. And then at paragraph 24 onwards, Lord Justice Mill sets out guidance from the well-known authority of M and Croydon. Paragraph 25, Lord Justice Mills restates states the principle that generally the unsuccessful party will pay the successful party's costs. Again, primarily a matter for the discretion of the trial judge. Paragraph 26 is cited, paragraph 49 of M and Croydon, which deals specifically where a case is settled. And Lord Justice Mills restates the principle. It's hard to see why a claimant who, after complying with any relevant protocol in issuing proceedings, is accorded by consent all the relief he seeks, should not recover his costs from the defendant, at least in the absence of some good reason to the contrary. And then finally, paragraphs 38 and 39, Lord Justice Mill's judgment is, the point is made that essentially the summary assessment process must be kept within the bounds of proportionality. And then, sorry, in 42, before we leave this, the principle that a judge, a trial judge dealing with the cost application, is entitled to express his reasons shortly. So with those in mind, my lord, if I can turn to the grounds, and I understand the first ground essentially to be, well, a renewal hearing had to take place because of the terms of CPR 54.12. My first point is whether it's right or not, the interested party still took over the defence from the 5th of February. So even if there had to be a renewal hearing, it was the only party defending the claim, and it was a matter of discretion for the trial judge to decide it should pay costs for that day. But in any event, in my submission, the appellant is wrong. By virtue of section 31(3) of the Senior Courts Act 1981, leave of the court is required for any judicial review. Now, the procedure for the grant of leave is found in part 54. I believe that's at tab 8 of the bundle. I'm afraid I don't.
It is.
It wasn't sent
It
in
is.
the British bundle. So, if one looks at the rule that my learned friend relies on, which is 54.12(3), which deals with where there has been a refusal on the papers, subject to paragraph 7, the claimant may not appeal, but may request the decision to be reconsidered at a hearing. So the claimant will have to put in a renewal notice, but there is no positive requirement for that hearing to take place. However, and indeed, in fact, the rules indicate that there positively isn't a need for a hearing, because if one turns to 54.18, that states the court may decide the claim for judicial review without a hearing where all parties agree. Now, of course, a stage in any judicial review is permission. That's part of the claim. So there's no proviso in that rule that permission can't be dealt with on the papers when there's by consent. Rather, the whole of the claim can be dealt with necessarily. Permission can be dealt with. my submission also of relevance to this is the overriding objective. Now that isn't in the bundle, but your lordships, I believe, will have access to the civil procedure rules. And maybe there's no need to turn it up, but CPR 1.4 provides that the court must further the overriding objective by actively managing cases. And active case management includes at 1.42F, helping the parties to settle the whole or part of the case, and at 2J, dealing with the case without the parties needing to attend court. And of course we know that in interpreting the civil procedure rules, the court is required to give effect to the overriding objective. So, my lords, if there were any doubt about the terms of 54.12.3, then in my submission it should be interpreted in line with the overriding objective, which includes dealing with the case without the parties needing to attend court. But, my lords, I say there is in fact no doubt. I also rely on CPR 40.6, which I believe is behind tab 7 of the bundle. Which deals with consent judgments and orders. And subparagraph 1, the rule applies when all parties agree the terms which a judgment should be given or an order should be made. Now, my learned friend, I think, looking at subparagraph 2, appeared to be saying, well, this rule doesn't apply because it's a judicial review. In my submission, my lords, that is wrong. All subparagraph 2 does is set out where a court officer can make particular orders. And there are some that are appropriate for a court officer to be made. Of course, there are some which must be made by a relevant, whichever judge is necessary. And when one's dealing with the quashing of a decision, then clearly it will be necessary to have a High Court judge. And then particular relevance 40.6, subparagraph 6, the court may deal with an application under paragraph 5 without a hearing. And an application under paragraph 5 is in a matter where paragraph 2 doesn't apply, i.e. a court officer appropriate decision. Any party may apply for a judgment or order in the terms agreed. And again, no carve-out or exception there for where there's been a refusal on the papers and a renewal application has been made. And my lords, as Lord Justice Singh highlighted, the effect of my appellant's submission is that where there's been a refusal on the papers, but then it becomes clear to a defendant that actually the claim should be conceded. And that may be because of counsel's advice, it may be because there's been a judgment of an appellate court, which means that its position becomes indefensible. Now, on my learned friend's case, the parties would not be able to deal with the matter by consent. They would have to turn up to court for a hearing. And in my submission, absent any clear rule or statute or case law setting that out as the case, in my submission it was wrong, and it's patently contrary to the overriding objective, the terms of CPR 40.6 and 54.18. So, my lord, then the question remains, well, if that's the case and there isn't a legal requirement for a hearing to take place, the question is, was there an adequate factual basis before the judge below to reach the decision which she reached? And if one goes to the reasoning of the judge below on page 28 of the bundle, paragraph 11, we see there the consideration of these submissions by the interested party, the clear statement that the interested party in her judgment took the burden of defending the claim by applying to file the acknowledgement service out of time, she deals with an amendment which I'll come on to later. And then about 8 lines down, halfway through, absent the interested party's position, an oral hearing and the preparation for it are unlikely to have been necessary, and the subsequent costs very much reduced. My lords, the refusal of permission by the High Court was on the 26th of January. On the 30th of January, the second respondent, the council, confirmed by email that it would maintain its concession on the basis of ground 4. And I highlight ground 4 at this stage because that will become relevant later. Now, if I could just turn to this correspondence, because it is quite important, page 60 of the bundle.
Page 60?
60, yes, madam.
60, thank
Yes.
you.
Yes, so here the council, this is Mr. Dupre at West Suffolk Council, to Anna Russell-Nee, who's my instructing solicitor. Confirmation there that the council would maintain its concession, as previously indicated, that was ground 4. And then it was the council's view in that email that the oral hearing would be necessary. On page 61, there is the reply from Ms. Russell-Nee, and in the final sentence of that reply was the clear hope that the oral renewal hearing would not be needed if proceedings could be swiftly brought to an end. Then, my lords, if I could ask the court to turn to page 67 of the bundle. Again, this is the same date, the 30th of January. My instructing solicitor wrote to the court, informing the court that the consent order was being finalised, and the last sentence of the first full paragraph. We therefore hope that an oral renewal hearing will not be necessary.
I'm sorry, which page is that?
Oh, I'm so sorry. Page 67, my lord.
Oh.
So it's the last sentence of the first full paragraph.
Yes, thank you.
Then,
Sorry, can I just be clear? At this time, was it the position on behalf of the claimant that a concession only on the basis of ground 4 would be sufficient?
yes, my lord, it was.
Because the judge certainly records that
Yes,
as being the claimant's position in late November.
yes, my lord.
So that had not changed.
That had not
Is that
changed.
right?
That had not changed.
So I don't want to interrupt your submissions at all, but just so I can see the structure of your case. At base, is it your submission that the judge was entitled to take the view that as a matter of common sense, this case was pretty much going to be over from late November?
Yes.
Even if not all the grounds were conceded, but in practical terms, the case was over,
Yes,
so far as the claimant and the defendant were concerned.
yes, my lord.
And that and what follows from that, as I read the judge, is that from the 5th of February 2019, she concludes that as a matter of reality, it was the interested party's stance which prevented the case from being concluded by consent.
Yes. Absolutely right, my lord. And in fact, I'm just coming there because if one would ask the court to turn to page 99, please. Of the bundle. Now, this is an email from Mr. Dupre to Ms. Russell-Nee dated the 8th of February 2019, but it looks back in time, and if one looks at the final paragraph of that email, is Mr. Dupre detailing conversations he's had with the interested party. And your lordships may have understood from the bundle already that the interested party wasn't communicating with my client, but was communicating via the council. at this stage. And then the final two sentences of that paragraph, it was on the following Wednesday, 30th of January, that I conveyed our decision to maintain the concession on ground 4 in writing to yourselves and the agent. After I did this, I received communications urging me not to sign a consent order and indicating that Sharp Pritchard were being instructed. So as around 30th of January, the interested party began to take issue following the refusal of permission on the papers. That was then first made public on the 31st of January, which one sees on page 69 of the bundle. And this is a letter to the court from the interested parties planning consultants, dated 31st January 2019. And the final paragraph of that confirms that the interested party did not make any concessions, and following council's advice, it's our clear understanding that even if the judge grants permission for judicial review, the planning permission cannot be set aside unless all the parties, including Mr. Collins, agrees to it, or if so, decided by a judge at a substantive hearing. So that, again, this is correspondence before the interested party becomes liable to pay costs. My lords, even after that letter had been sent, it was still the position of the first respondent to try and get the matter dealt with by consent. And that can be seen on page 86 of the bundle. Page 86 of the bundle, email dated 1st of February from Ms. Russell Nee to Mr. Dupre. Halfway down, please note JR renewal hearing has been provisionally set for 21st of February. We're hoping, of course, that this hearing would not need to go to head. Therefore, if we are to vacate this hearing, saving additional unnecessary costs, we've been urged to file a consent order with the court as soon as possible. My lord, that's the short answer to my learned friend's point about the hearing date being set before the acknowledgement of service was filed. Of course, any hearing can be vacated. It wasn't set in stone, as my learned friend appeared to be submitting. And then, just to complete that conversation between the council and my client's solicitor, on page 96 of the bundle, on the 4th of February, Mr. Dupre for the council replies on this issue, and the second paragraph of that email states that I've been advised by our council that the High Court is quite likely to allow the interested party to enter the case. The result of the hearing on 21st of February will be necessary regardless of the council's position. It seems it's therefore that it is not possible for the case to be resolved by a consent order signed by any two parties, at least until the interested party status is clarified by the court. So then, as we know, the interested party the next day, on the 5th of February, filed its acknowledgement of service out of time. And I've already noted, taken the court's attention to the fact that the Aarhus status of the claim was contested. But can I just, one point I missed on page 80 of the bundle, and these are the summary grounds by my learned friend. Paragraph 10 of those summary grounds, it states, the interested party makes no observation on costs, save to indicate that in the circumstances, the interested party can properly seek costs for all stages of this litigation. Well, my learned friend, if it was my learned friend's view that the interested party could seek its costs, well, clearly could also be liable for costs. My learned friend can't have it both ways. There was then, the renewal hearing then had to happen. And we've been briefly to the transcript. if I take the court to page 206, please. This is the part where my learned friend takes the opportunity to make submissions on costs.
Sorry, page.
206, my lord. It's the second trial bundle. And the exchange starts between letters D and E. My learned friend seeks to argue that the claim was not an Aarhus claim. Mr. Justice Holgate highlights that he's bound by the case authority of Venn, which was against my learned friend. And then towards the bottom of that page, there's a question from Mr. Justice Holgate, which is the issue of the cost cap. Mr. Justice Holgate says really affects the local authority. Straker, it affects them more than me. Mr. Justice Holgate, well, it would only affect you. I'm so sorry, you're right. It affects you if you alone decide to go ahead with the challenge. And then at the top of the 207, Mr. Straker says, yes, because if I'm in the circumstances, it sometimes happens, local authority having dropped out as and my defendant. And then Mr. Straker suggests that the cost cap should not be reduced. Now, my lord, in my submission, even at that date, the date of the renewal hearing, the interested party was the sole defendant because it was the only one that had filed an acknowledgement of service in defending the claim. And my lord, on that point, I think my learned friend sought to make some distinction between an acknowledgement of service with summary grounds and then the detailed ground stage. And effectively, one was only defending the claim at the detailed grounds. I may have misunderstood that. If that is the submission, in my submission, it's plainly wrong because of the terms of CPR 54.8. Should be at tab 8 of the authorities bundle. Where it's right to say that subparagraph 1 makes it clear that it's about whether a party wants to take part or not. And then, but at subparagraph 4, the acknowledgement of service must where the person filing it intends to contest the claim, set out a summary of his grounds for doing so. So, my lords, in my submission, it's clear that once one submits a ground of service, or files a ground of service which has grounds for contesting the claim, it can properly be regarded to be defending the claim. My lords, you have my submissions and we've been to the acknowledgement of service.
Mr. Straker drew our attention to paragraph 15 of your submissions on costs. You coming to that?
Yes, yes, my lord. I deal with that now. The primary position of my client was that all of her costs should be paid by the council. But then a secondary submission was made. If I go to my submissions, which can be, they start on page 34 of the bundle.
Sorry,
my cost submissions, which are page 34.
To this court? Or?
No, my lord, to the High Court.
Do they?
Yes, my lord, because what happened is there were submissions.
Yes.
With a witness statement.
Oh, then a reply.
And then a reply.
Yes.
So if I just start with my submission.
Yes.
And at paragraph 2, there is confirmation that the preliminary submission, the entirety of costs ought to be paid by the defendant, and then in the alternative, the claimant applies for its costs up to 5th of February from the defendant, and from 5th of February 2019 from the interested party. And I dealt with it very shortly, but at paragraph 10, just the very simple point that it was as at that date the interested party commenced its defence of the claim. And then in the witness statement attached to that, my instructing solicitor divided the amount of the costs, paragraph 34 of her witness statement on page 42 of the bundle. So a figure was provided up to 5th of February and then a figure for thereafter to assist the court. That application was obviously supported by the numerous appendices to Miss Russell's witness statement. The interested party and counsel then made submissions, and in reply, I wrote a 3-page reply, page 144 of the bundle. And my lords, on instruction, the case was that the council should pay, as I say, in the first instance, all of the costs, or as much of the costs as possible. And so in reply, at paragraph 15, I stated that the renewal hearing was an ordinary incidence of litigation arising out of the refusal of permission. Now, nowhere there do I say, my lord, that was because a hearing was legally bound to happen. Indeed, it wasn't my submission. But I did submit that, in fact, it was just an ordinary incidence of the costs that ought to be paid by the council. And the simple point is that the judge below disagreed as a matter of her judgment. And she had the information before her, the factual background, all of the emails I've taken your lordships to reach her decision.
So the division of costs in paragraph 34, saying prior to the 5th and from the 5th, all the costs of the hearing before Mr. Justice Holgate are included within the latter.
Yes, ma'am. Yes, ma'am. So broadly, those are my submissions on ground 1, which take us up to the date, take the court up to the date of the renewal hearing. There is then the issue of costs thereafter. And again, my headline point is this is essentially an attack on the judge's exercise of her judgment. In terms of facts during and after the commission hearing, my lords, much is made by the appellant of the amendment to my grounds. So, my lords, if one turns to the transcript in volume 2, page 205, one sees the suggestion from Mr. Justice Holgate for an amendment to the grounds. And it's right at the bottom of page 205. I think permission has to be granted here, I'm afraid. There may be a need for an amendment to the grounds, not to make them, as it were, even longer, but just to make sure in their final form they say what needs to be said. The council is proposing to submit to judgment in any event on ground 4, and your client may well wish to think further about it and allow all this to be determined in the round. That's a matter for your client. And then confirmation from Mr. Justice Holgate. I'm just expressing the hope that this case won't come back. So a clear indication there to the interested party that it may not want to defend the claim. My lords, there's a suggestion of amendment, and again, it would take reading the whole transcript, but there wasn't, in fact, a clear indication from Mr. Justice Holgate what that amendment should be. I had some discussion with him about the basis for the claim at the renewal hearing, and it did, and it's right, it did take the opportunity to amend the grounds, but as I'll show your lordships, there wasn't, in fact, a wholesale amendment. But my primary position is this, that as a matter of judgment, this exact issue was looked at by the learned judge below, and she found that the fundamental ground survived and the amendment did not amount to replacement of the grounds. That finding has not been appealed to this court by my learned friend. It's not part of his grounds of appeal. Indeed, it's an exercise of discretion. My learned friend would have to show that it is perverse. My lord, that simply is not the case. But in any event, in my submission, the amendment is entirely irrelevant. First point is, of course, the basis of the judge's award below was that it was likely the matter would have been dealt with before the renewal hearing in any event. So, absent the IP's position and acknowledgement of service, and then the renewal hearing, there would have been no amendment. That was the basis for the judge's below hearing. The second point is ground 4, which is the ground on which the council was always prepared to concede, remained unamended. And then, third, permission, when it was granted, the permission by Mr. Justice Holgate, which can be found at page 100 of the bundle. The granted permission was not dependent on the amended grounds. Permission was granted for the judicial review to proceed. And then there was a requirement to serve amended grounds at paragraph 2 of the order. So it wasn't a case of my client turning up with a case that was unarguable and the judge changing the case and making it arguable. That wasn't the case at all. Otherwise, permission would have been wholly contingent on amended grounds. But then if one turns to the amendment that actually took place, it was indeed simply a reframing of the grounds. The original grounds 1 and 2 became ground 1, and then there was the addition of ground 3. And my learned friend highlights that there was a significant amount of underlining. Well, there was, because the grounds were reframed and rephrased. My lords, it would be a lot, I'm absolutely prepared to do it, it would be a long exercise, but I can take your lordship through each paragraph and where the original ground is and where it appears in the amended grounds. But in my submission it's not necessary because the judge below has already looked at this and decided as a matter of her judgment that the grounds effectively remained and there was no wholesale amendment. My lords, by way of example, one turns to page 220 of volume 2. One sees ground 1 set out. The council's treatment of the use of the development applied for was unlawful in that. And then the sub-paragraphs there. And then the paragraphs which follow, which then if one keeps the thumb in that and turns to the original statement of facts and grounds, grounds 1A, 1B, 1C on page 179. And ground 2 on page 182. Are effectively amalgamated together and then become the new ground 1. And as I say, I mean, some of this text has just been lifted verbatim from the old grounds, and then some of it has simply been rephrased. But I mean, if the court is interested and would wish me to do it, I can go paragraph by paragraph to demonstrate that there simply wasn't a wholesale amendment. But as I say, it's a matter for the judgment of the judge below, and that hasn't been challenged by my learned friend. So, my lords, I'm in your hands, noting that there's...
Anything you want to read? No.
For my part, could you just show me where in the judgment the judge deals with that?
Yes, my lord. Page 28 of the bundle. paragraph 11 of the decision.
Oh yes, I've got it now. Thank you.
Yeah.
Thank you. I remember now. Thank you.
So, my lord, that, as I say, if it interests the court, I'm quite prepared to go through that exercise. So, my lord, that was the renewal hearing, and then there were the renewal grounds. Now, and my learned friend said to the court, well, the 8th of April, the interested party conceded the claim, it didn't cause additional costs, etc. And the timeline was essentially being put that was the next thing that happened. Of course, it wasn't. In fact, the interested party remained active. And if I can ask the court to turn to page 102 of the bundle. And this is a letter, an email dated 11th of March by Ms. Russell-Nee to Mr. Dupre of the council. And it records a telephone conversation had between them on the 28th of February. And if I could just ask your lordships to read the first two full paragraphs beginning in light that telephone conversation. So what they're being reported is that the interested party was lobbying the council not to concede, to go back on its concession. And then, my lords, it's not in the bundle, but on the 3rd of April 2019, the interested party asked for an extension of time to file detailed grounds of resistance. And I believe that was, and by consent between the parties, I believe that was refused by my client the next day. And then it was on the 8th of April 2019 that there was a confirmation that there wouldn't be detailed grounds. Now, thereafter, it's true to say there was correspondence regarding the consent order, and it was the position of my client that the concession should be properly made on all full grounds, and that's what the council agreed to. And I think my friend's point is, well, that was unfair because that wasn't something that the interested party was particularly involved or interested in. But that submission, again, was dealt with by the trial judge below. I'm just going back to page 27, please, this time. And it's paragraph 9 of the judge's decision. I'll just ask your lordships to read that. So, my lords, again, the matter explicitly considered by the judge below, and as a matter of her summary judgment, remembering in the case that these summary judgment has to be dealt with in a proportionate manner, she did broad justice, which is the phrase she used, set off costs that would have been expended as a result of the interested party prior to the 5th of February versus costs that would have been attributed to the council after the 5th of February. Again, matter for her judgment, and my learned friend doesn't show that that was perverse. If my learned friend, again, I think the submission has been made effectively that there were no costs as a result of the interested party prior to 5th of February. Well, my lords, I've taken your lordships through some of the correspondence in late January, which clearly involved the interested party. It's also true to say that the interested party, though it confirmed that it would not defend the claim off the bat before there was a refusal on the papers, it also refused to sign a consent order. So, my lords, there was a sufficient factual basis for the judge below to reach her judgment. And in my submission, that judgment is entirely lawful and indeed not surprising on the basis of the facts of the case. So, well, unless I can assist you further.
No, thank you very much indeed. Yes, Mr. Green.
My lords, 2 points. First, whether or not it was necessary for there to be a hearing following the refusal of permission by the High Court earlier. In my submission, there was no such requirement. My Lord Justice Popwell referred to CPR Rule 54.18. This was explored in more detail by my Lord Justice Singh. The court may decide the claim for judicial review without a hearing where all the parties agree. Rule 54.1 defines what is a claim for judicial review. CPR 54.12 says in this section A, a claim for judicial review means a claim to review the lawfulness of and then various matters. 54.4 goes on to say the court's permission to proceed is required in a claim for judicial review, whether started under this section or transferred to the administrative court. My Lord, a claim for judicial review exists when it is initiated, and it will continue to exist until finally disposed of. The grant or refusal of permission is one stage in the process, but a claim for judicial review doesn't cease to be a claim for judicial review just because permission has been refused on paper. So in my submission, CPR 54.18, which gives the court the power to dispose of a claim for judicial review without a hearing, that applies from the moment a claim is issued up to the time it is finally dealt with. So there is no impediment in my submission under the rules to the court dealing with a renewal application on the papers, had the parties all consented to it. My Lord, the second point is this: what more could the local authority have done to bring about a settlement of this matter and avoid further cost than it in fact did in this case? In the first bundle at page 99, Mr. Dupre, for the authority, tells the claimant's solicitor what he did. It's an email of the 8th of February 2019. It was responding to a request for documents and information, but what's said in the second and third paragraph are relevant. As you would expect, I informed the agent of our decision to consent to judgment on the same day that I made our intention known to your firm. My Lord, that was the letter of the 29th of November 2018. It was at page 46 of the bundle. As stated in my email to you of the 7th of December, I received an acknowledgement but no substantive response. Likewise, on the 21st of December, I sent the consent order to the agent and received an prompt and brief acknowledgement but no further response. As my email to you of the 4th of January indicates, the source of my knowledge was a telephone call from Mr. Collins the same day. And my Lord, that email of the 4th of January, that's at page 49. And that's where the interested party had communicated to Mr. Dupre that although he would not resist the claimant's claim, neither would he sign a consent. Since then, the authority's position has remained entirely the same. It would consent to judgment. Initially, it indicated it would consent to judgment on ground 4, the reasons ground, and that was acceptable to the claimant. Had the interested party not actively opposed settlement, had not actively opposed the claim, the matter could have been settled by way of a consent order before or after permission had been refused on the papers. And the hearing before Mr. Justice Holgate could have been avoided, and all the costs flowing from that. But instead, as your lordships have already seen, on the 31st of January, at page 69 of the bundle, the interested party's planning consultant writes to the court to make clear that the interested party was essentially opposed to the claim, that Sharp Pritchard were to be instructed in the matter, that Timothy Straker QC had advised that Mr. John Harrell's QC's reasoning is correct. The situation is not one in which judicial review should be granted. So, my lord, that was a clear public indication that the interested party was going to take up the cudgels. And that led, as we have seen, to the filing of an acknowledgement of service and summary grounds of defence a few days later on the 5th of February. In my submission, the judge below might have taken the 31st of January as the appropriate point at which to say the interested party became a combatant and should therefore become liable for costs, but she took the 5th of February, the date on which the acknowledgement of summary grounds were filed, and in my submission, largely for the reasons already given by Ms. Hutton, she was in my submission entirely within her discretion to do so, exercising the broad, summary and proportionate jurisdiction and cost. Unless there's anything else.
No, thank you very much. Yes, Mr. Straker.
There are some points, my lords, which ought to be noted with some care, because what is being suggested is, in my respectful submission, very much opposed to what happens and what is intended to happen as given by the CPR. Both my learned friends have referred to CPR 54.18 as being a foundation for them to say that this matter could have been resolved without the intervention of a hearing involving Mr. Justice Holgate. If one looks at 54.18 at 11:13, the answer which I gave to my Lord Justice Popplewell remains extant and undisturbed by anything that my learned friends have said. And if you look back over the preceding pages of the CPR 54, you will inevitably notice that what is happening within the CPR 54 is that it proceeds sequentially. That is to say, and it contemplates first the question where you need permission, then the question of the claim form and its service, then the question of do you have permission to embark upon your claim, then permission having been given, what you have to do, 5410, 5411, and then the position 5412, permission without a hearing. You now have arrived at the circumstance that there's going to be a hearing. The defendant may not apply to set aside 5413. 5414 is your response when you are served with the claim form and you wish to contest the claim form. We could contest the claim or support it on additional grounds. And then my learned friends say, well, look on to 5418. Overlook, if you don't mind, what comes between that which I've just identified at 5414, 5415, additional grounds, 5416, evidence, court's powers to hear any person, 5417 and 5418. It is plainly a sequence which is happening here, leading up to a moment when it is considering the claim for judicial review, not the claim for permission to seek judicial review. And if it were the case that 5418 enabled the court in the circumstance under consideration, that is to say, post-refusal by the Deputy High Court Judge, Mr. John Howell, before any other judicial consideration, for the parties then to say, the local planning authority say, now unhappy with its decision, and the claimant who doesn't like the planning decision, then to say, oh, well, we all agree that this can be got shot of, and we can do it without a hearing, a judicial review, you would have bypassed a significant part of the process. So in my respectful submission, 5418 simply is nothing to this particular point. It simply deals with the circumstance which arose in this case when Mr. Elvin came to consider the case, and he decided the claim for judicial review, which by that time had been granted permission courtesy of Mr. Justice Holgate, to proceed as a claim for judicial review. He considered that without a hearing and made the order that he did, which your lordships have seen. So 5418 doesn't get my learned friends to be able to say that the hearing in front of Mr. Justice Holgate was an unnecessary step. And of course, Miss Hutton has said completely the contrary, that it was an absolutely necessary step. 5418 doesn't enable it to be said it was an unnecessary step. And similarly, the reference to CPR 40 is to be met in this way. First, that one was proceeding and always proceeding under CPR Part 54. And second, and in any event, nowhere is there a hint before today, effectively, nowhere is there a hint by the claimant, Mrs. Easter, oh, well, we can now use CPR 40 or CPR 5418 to short-circuit all this. On the contrary, the correspondence is all to the effect, namely that a hearing is necessary. And then the only question, in my respectful submission, which can conceivably arise as far as that hearing is concerned, the only question is someone in the position of Debenham Antiques Ltd, who has put in an acknowledgement of service after it had been acknowledged that there must be such a hearing, see the correspondence, to be penalised by virtue of turning up and trying as best he might, which no doubt might not be very good, but Mr. Justice Holgate did say thank you very much, as trying as best he could to help the court. So where does that come from? in circumstances when the claimant has not done anything to say, look, we can bypass this hearing in front of Mr. Justice Holgate. We propose to write a letter on these terms. Why don't you write a letter on the following terms? And this Mr. Justice Holgate, no doubt, will have a busy list otherwise, and can accommodate it in the first 5 minutes without us attending. Nowhere does that happen. The only circumstance which occurs is recognition that there must be an application made to Mr. Justice Holgate, and indeed there had to be an application made to Mr. Justice Holgate. And then, with the greatest respect, it simply does not wash that post Mr. Justice Holgate there was any contribution to the costs exercise by Debenham Antiques. The only thing that my learned friend points to is, oh well, Debenham Antiques may have had some discussion with the council about this matter. Well, where do we get a liability for costs out of that, I respectfully ask. There can be no such matter. Now, my learned friend says, well, Mr. Straker can't criticise the change of pleadings because his grounds of appeal, whilst they've said that the judge was wholly wrong in every particular that she advanced, hasn't picked that out as a point of, so to speak, glory. You only have to look, in fact, at those grounds, and you only have to look, in fact, at what Mr. Justice Holgate came to say to Miss Hutton, page 190 of volume 2, that he was embarking upon, which is perhaps not surprising given Mr. Justice Holgate's background, immersed in the world of town and country planning, on a different approach to the case than hitherto had been advanced. That is to say, what is the lawful use to which you may be able to revert? Which was a different question, a wholly different question from that which had been posed before, namely that the council hadn't considered how the use inconvenienced or embarrassed the claimant in her occupation of her property. So, where do we get as far as all this is concerned? We get to a circumstance where what has happened is that my learned friend made, if I may respectfully say so, a perfectly conventional application for costs against the local authority who had conceded right at the end of this particular matter, let that not be overlooked, on all the grounds in which the interested party had hardly played a role. She made a perfectly conventional application saying the council should pay these costs. And that perfectly conventional application, in my respectful submission, could and should have been met. Yet we find ourselves in the circumstance of the judge saying, post the 5th of February, for everything you, Debenham Antiques, have got to pay, even though this was not your decision. You were not the person who ultimately had sway over whether or not the decision in all its aspects could be conceded to in all the grounds that were being sought. You were not and never were that person. You attended a hearing which had to take place in circumstances in which the claimant had made no move to prevent that hearing from taking place. Where is the procedural step that was taken to prevent that hearing from taking place by the claimant? None at all. You've got to pay for all that, even though that was necessary because of what Mr. John Howell had done, sitting as a judge, and even though Mr. Justice Holgate was kind enough to provide you, the claimant, with a basis upon which you could then proceed, which you did, upon which we said we're not going to take any part in this, and the council then maintained an argument until somewhat later. There was a kind of throwaway, 2 paragraphs at the end. Well, if you don't like it, as far as the council is concerned, why don't you dump some of these costs upon the interested party? and that was taken by the judge to go all the way back to this completely mistaken view that we had somehow or other caused there to be this hearing in February in front of Mr. Justice Holgate, where there was no causative relationship between what we did, no causative relationship at all between what we did and that particular hearing. You cannot identify a causative relationship, partly because there was no position capable of being taken under the rules other than to have a hearing, and partly because, no doubt because of that, no step was taken by the claimant, or anybody else for that matter, to avoid that hearing by saying what they now say, mechanisms which can be pursued. So in my respectful submission, I repeat, if you go through that paragraph 11, line by line, sentence by sentence, each one of them you find to be wrong. And therefore, I most respectfully say that even though one hesitates long and hard before coming to this court over a costs matter, and you've seen what has been attempted to be done in connection with that, and one hesitates long and hard, nonetheless, this is something which ought to be corrected, and in my respectful submission, should be corrected. And may I just check two references. Yes, if you look back, my learned friend drew attention to page 60, and where she draws attention to an email from the council to the solicitor for Mrs. Easter. And the middle paragraph records the acknowledgement that an oral hearing is necessary, notwithstanding the council's concession. If you go back a little further to material which wasn't drawn attention to in that little exchange, but look at page 58. Please can you give us an indication as to when we can expect to receive this council's substantive response, bottom of the page, to our letter. Council is currently preparing our grounds for renewal. In other words, this is what we're going to do. And we're attending the planning court to file our renewal application tomorrow morning. And so that is an application made under CPR 54, where there has been a refusal and where the person wishes to renew it by way of having a hearing. In other words, 5412, please may I have a hearing. And that was necessary and took place.
Thank you very much. Thank you all very much for your submissions. We are going to reserve our judgment. It will be handed down either remotely or in court, but in either event, no one need attend. And we would hope that you'll be able to agree an order, but if any provisions can't be agreed, then short written submissions and the matters will be decided on the papers.
Much obliged.
Thank you.
Court